So if you've ever said to yourself, I wish there were settlement funding companies that charge less than 20 to 30% interest to my clients. I wish my client had more time to figure out how to handle the settlement proceeds once a settlement was reached. I wish there was a way for my client to earn more than annuity rates on the settlement proceeds. I wish I knew who to call for help setting up a special needs trust, a Medicare set-aside, a government benefits preservation vehicle, if you even knew such a thing existed. I wish I knew how my firm's financial outlook for the year was going to be before I had to decide to take my fee, so I could know whether maybe I could extend those fees into next year when I got more to write off against it. Frankly, my last real wish was I wish I understood how the contingency fee deferral really works. By the end of this next session, all of those wishes will be granted. By the time John's done, I expect you're going to learn that you can earn money on your fees using pre-tax money. You can take your fees when you want them, and you can offer your clients real-world assistance in getting to trial and maximizing their outcomes. A little bit about John. After graduating from West Point with a double major in mechanical engineering and Spanish, John was a captain in the U.S. Army, working as an AH-64 Apache aviator, a commander, aviation officer, and aviation risk manager from Alabama to South Korea. After meeting his military obligations, he started in the settlement management industry back in 1999, working at EPS Settlement, and then starting his own group, Forge Consulting, and now that's evolved into Milestone, founded almost 10 years ago. Not content with just making money, John has also nurtured his experience doing pro bono settlement work for families of victims from the 9/11 attacks. And then almost 6 years ago, we started up Bair's Foundation, and that's a not-for-profit foundation that provides non-recourse, meaning lawsuit funding, and he can tell you how it differs from offerings we see from others in the industry. More recently, meaning literally within, I think, just the last couple of months, Milestone showed its commitment to civil justice by launching the trial, I'm going to try and do the pronunciation right here, the Trial Law Her Scholarship, intended to promote female trial lawyers. It's an annual $10,000 scholarship open to rising third-year female law students who intend to become plaintiff trial lawyers. By the way, applications are currently open, and no doubt John's father-in-law, who just happens to be a federal magistrate judge in Buffalo, approves. With that, I'm going to hand the reins over to John.
Thank you, Mark. I think you did my presentation for me. I said that yesterday. But it's great to be a part. I've actually enjoyed meeting and getting to know many of the ARLA members. I really enjoy working with railroad lawyers amongst aviators. So it's the engineer in me. So I'm going to take you through and leave plenty of time for some Q&A. But Mark hit the nail on the head with some of the highlights. I want to take the first few minutes and talk about our foundation first, because it's kind of in order of litigation. So my wife and I, about 6 years ago, started the Bair's Foundation. It's a public charity, a 501c3. We do take donations. But fundamentally, we created it because I've seen in the settlement space for the last 25 years that loans to plaintiffs, the guys you represent on the railroad, range anywhere from 30% to 100% interest. So if they borrow $10,000 or $20,000, they may pay back $100,000 or $150,000. That makes the cases hard to settle, and it's just downright wrong, candidly. The whole movement around, and the New York Times had an article last week where hedge funds and private equity firms are literally pouring billions of dollars into litigation finance. They're trying to get into the profit sharing of law firms, and that's okay. If a lawyer decides, hey, I want to borrow money at 18%, that's all available. But the families probably don't have access to capital, and when they become financially destitute, they really shouldn't be taken advantage of. And so that's why we did it as a nonprofit. So there's no profit in the taking advantage of somebody when they're down. So we loan, and I'll say this twice, we loan money to families at 9% simple interest right now. It obviously fluctuates with where interest rates are, but that's unheard of. There's no one in the country that's doing that. So if you do have someone that just needs, $1,500 or $2,000 a month, we prefer to do monthlies instead of giving them a lump sum. It also reduces the amount that they'll borrow over the course of litigation. And it's just a great benefit. We've raised a few $1 million. We've got a few $1 million out in our fund. We're coming up on having helped over 1,000 plaintiffs since we started. So it's just a good story, something I'm happy to talk more about. But I'm sure most of you are intimately aware of, what the cost of litigation finance is. And so we're happy to be able to do that. I think what Will, Moody, and Mark were, more likely very intrigued and interested were a lot of the financial things for law firms. And so I'm going to do a primer to the extent that you raise your hand if you feel like you're an expert in qualified settlement funds. I don't expect many of you are, but if you haven't always done railroad work, or if you have a very complex firm and you have partners that do mass torts or anything like that, then those opportunities you may have come across them. But fundamentally, in our opinion, the way to plan the revenue, the peaks and valleys, as Mark was saying, is by using a qualified settlement fund. So going to fundamentally, a qualified settlement fund is a court-ordered trust. And so our firm administers a few $1 billion annually that are any types of settlements, not just railroad, obviously. Mass torts, individual birth trauma cases, product liability, you name it. So we're very, very deeply experienced in the creation, jurisdiction, the custody, et cetera. And so qualified settlement funds have been around since the early 80s. The tax code is there for you guys if you want. I can do a follow-on packet. But there are a couple of rules. It has to be a tort or breach of contract, tort or tort right. So any personal injury case or field case can apply. Fundamentally, your benefits, and I think you're talking about risk reward. There's really not any downside to a qualified settlement fund. What you're doing is creating time and space to plan. And so I'll give you a quick example. If you settle a case in July for, say, $2.5 million, and you have the client's share and your fee, it really gives both your firm time, and qualified settlement funds allow up to 18 months or the following calendar year for you to take your fee. And because the legal definition of a qualified settlement fund is no different than defense counsel's escrow, having a third party who is aligned with the trial bar and committed to civil justice makes a lot of sense. So you just have to be comfortable with the security framework. But fundamentally, the biggest benefit is time to plan. You may settle a number of smaller cases, a couple, $300,000, $400,000, $500,000 cases. But if you're having a good year and you don't want all that in 2021, the one thing I want you guys to remember from this presentation is that the qualified settlement fund is going to give you that extra year, that extra cure time, so you can balance some of that revenue from 2021 to 2022. And on individual calls, I can explain the mechanics exactly how that happens. But that's the big planning feature for you as attorneys, is to just buy that extra year. A lot of law firms come to us for the sole reason of they settled a case in October or November and they really want it in January, February. So they have it paid to the qualified settlement fund. QSF do a lot of other things. It preserves the ability for both the lawyer and the client to create a tax-exempt or tax-deferred payment stream to the extent that that's desirable. So you haven't taken constructive receipt. You receive the monies in your firm, so you can do a deferral as a contingency fee lawyer, as well as a client, and it's tax exempt for the client. It's tax deferred for you lawyers. And there's a couple of different ways to it. Mark mentioned buying an annuity. I've probably done over $2 billion worth of annuities since the late 90s, but they're no longer an attractive financial vehicle. And so since 2003, we've actually been able to create periodic payments or tax deferred and tax exempt obligations with investments. So I'll talk you through what a little bit that looks like. But what we're talking about is that time to plan. If you hit a big case or you're just having a great year and you know you're not going to need that money for 5 to 10 years, you can do a pre-tax investment, meaning you're not going to recognize any of that revenue in the year you settle the case. And so that's a huge benefit. It allows you to control your income and your taxes. And it's unlimited. I mean, so you look at the comparisons, you can only defer up to like $50,000 in a profit sharing plan, about $17,000 in a 401k. The IRS is after your earnings. And the reason that this tax deferred exists is because the IRS lost in '96 in the 11th Circuit case. So it's that time to plan. And what I found in representing, we only represent plaintiff lawyers as our clients, is that when they're settling a case, they may not be thinking about their tax position, come April next year. I mean, some do, but some are just moving right on to the next case. And so just having some time to think about it, safeguarding the assets in a qualified settlement fund, having a conversation with partners or your, spouse, just getting the conversation going and being able to have time to reach out to experts and work with whoever you want. That makes it real viable. Whereas if you, without the qualified settlement fund, you're settling a case and the money is coming in to the, IALTA account and you're paying the client. And so it's just a foregone conclusion that you're paying taxes on that. It's pretty straightforward on how to use a qualified settlement fund in any case. So we recommend that you get one set up for your firm. You can do them on individual cases, so one at a time. It's a little more cumbersome. But most of the sophisticated attorneys we do work for will set one up for their own law firm settlement fund. And with us as managers, then we just have the W-9, the tax ID, and lawyers. And I spent a lot of time talking to Mark and Will about this, is that if you're negotiating with the railroad, they need to understand that the payee of the consideration in the release is your qualified settlement fund that you got established. So the payment from the railroad or whoever the defendant or insurer is goes directly to the qualified settlement fund. There are candidly 3 types. I mentioned there's individually ordered ones, firm qualified settlement funds. And there's also, if there were, say, a train accident and there were 50 plaintiffs, or we've done these in mass torts, we've done them with aviation accidents, when you have real complicated issues and allocation of settlement proceeds. The qualified settlement fund is really perfect for preserving all the tax benefits, but allowing other experts, special masters, people that may do allocation work or lien work, et cetera, come in and finish out the work before those monies are prepped for distribution. So typical timeline, you're negotiating a case, you're going to want to see the qualified settlement fund be a term of settlement. You just have it in the mediation agreement, or you have a verbal contract with the defense lawyer. It's established pursuant to court order. Requires the defendants to pay into it directly. Our fund, we coordinate all the disbursements with your firm. So you're a signer under the escrow agreement, is how it operates. Gives you full control of, if a lien is going to be paid, so no money ever moves in a qualified settlement fund without the express written direction of the leading plaintiff lawyer that's on the escrow agreement. We handle all the taxes. It's its own tax-paying entity, so that there's a fiduciary tax return that's required. And at the end of the establishment and creation of a qualified settlement fund, and if all distribution has been made, then our firm does a full accounting to the extent that any lawyer may want or see, to include bank statements or an actual accounting process. And just to caveat this, there's a lot that goes into these, but we have made qualified settlement funds very, very streamlined from an expense perspective. It's typically about $2,500 to get set up into one. And our fee, or anybody in the business, and not all, but not banks certainly, but real specialized qualified sum fund administrators will more than likely take their fee as just the float or the interest that's made on the deposit. So you can represent that by paying the settlement to a qualified sum fund, your client isn't incurring any fee or expense. Just basic things to expect from an administrator. The assets will be custodied at a major bank. You can have FDIC insurance all the way up to like 500 million. We have high specialization with the banks and Promontory and different systems to get FDIC coverage. So you should not be concerned whatsoever about the depository risk. We obviously work with really big banks, but to the extent that you want to make sure you're comfortable where the deposit is. And that's also transparent. You have view access as a leading lawyer, et cetera. So we coordinate distributions to the client, so you have the option. If you want to have the money come to your IOLTA account and you want to pay the client, that's your discretion. You can direct us as the administrator to pay the client directly. So it's whatever. A lot of lawyers prefer to put checks in their clients' hands. So moving into the fee deferral discussion, I may just stop there and see if we've got some questions around qualified sum fund, their use, their benefits, how to get them set up, and the taxes associated with them. I can certainly take questions at the end too, but if there is anybody that wants to jump in.
So John, we've had one already asking, is the deferral of fees, that deferral year, is it 12 months from the date of the distribution, or is it the whole 12 years following the post-settlement distribution? So is it just 12, or is it potentially up to 24?
It's potentially up to 24. So it's calendar year end of the following year. So if you settle in January, you're buying 23 months. If you settle in November, you're buying 14 months. You have to take a distribution from the qualified sum fund before the close of that following year.
Now, have there been any bar association letters or ethics opinions regarding that have approved the placement of client money through a QSF?
So, great question, Mark. There's no issues whatsoever in all 50 states where a qualified sum fund is client money, because under the law, what a qualified sum fund is it's a court order escrow or settlement escrow account. So it's not even client money yet. But you control the distribution and direction. So that's why I say it's no different than defense counsel's escrow. And so there are no ethics issues, there are no ethics violations of any kind with regard to the use of IOLTA. You can, of course, still use your IOLTA, but because it's a court ordered settlement account, it's not like client money yet.
So it hasn't touched the firm yet, and it hasn't touched the client yet, so it's still considered offshore, for lack of a better term.
Well, yeah, exactly. I mean, so we just don't have any issues with ethics and IOLTA. And that's borne out that this is how mass torts, tens of thousands of claim payments never go to law firms' IOLTA accounts. And we've been doing mass torts for, close to 20 years. To the tune of billions of dollars. If there were some ethics requirement that a lawyer must place their client's money into their IOLTA account, then there would never be a mass tort settlement. So we've vetted that, but just as a practical example, if you're going to pay money to your firm, my understanding, and I'm no ethics lawyer, but as I've talked to people in the industry that have had the same question, if you're going to pay money to your firm, then it must go to the IOLTA account. And so if you're going to handle distribution to your client, then of course, pursuant to ethics, it must go to the IOLTA account and be paid from there. But you can direct an administrator to pay your client directly. And that's absolutely legally proper.
Now,
hey, Mark.
Yeah.
It's Will. I just wanted to say to really confirm what John is saying is, our firm also has a collateral practice in mass torts. That's how I know John is. We have been using QSFs for years. Every mass tort settlement of every tort we've done has gone through one, and we open them. The money runs through it and is distributed through them, and I've never had any problems whatsoever with them.
How about the individual settlement funds? Are they segregated or commingled when they're in the QSF? And by the way, John, I don't have intelligent questions. I'm actually reading the ones from the smart people.
Yeah, no, it wouldn't matter whether they're yours or not, Mark. You have great questions.
It would, because it would make me smart, but they're not.
So because it's a court-ordered escrow account, all the funds are commingled until there's direction of the signing lawyer on the escrow agreement of where to direct that. And so if for example, if a $3 million settlement is achieved and that $3 million is paid from the railroad to the QSF, then that money would just sit there until the plaintiff lawyer directs where that's to be paid. And it might be a month later, they'd say, pay all $3 million to my IOLTA account. Here's the, wiring instructions.
Is it possible to have the client's portion sent right away while you're still holding off on figuring out what to do with the attorney fee portion?
Yeah, absolutely. And so a lot of lawyers, because that you're buying that time for just yourself, a lot of lawyers recognize that, look, my client doesn't want to wait. They're ready. So by implementing or creating and putting a qualified settlement fund in place, you may add 1 or 2 days at most with good administrators in terms of your distribution timeline. It's well within however long it would take the checks to clear from the railroad or whoever the defendant may be. We always recommend that trial lawyers negotiate wire, but there are just some entities that won't do wires and they'll send checks. But we turn around payments directly to the law firm to distribute to their clients, within 24 hours of the funds clearing. And we get that, even though you may coach and provide advice around comprehensive life planning and those type of things, a lot of clients just want their money. And so the qualified settlement fund doesn't mandate or create any obligation on either the lawyer or the client. It just preserves options. But if they want their money, that can be distributed right away.
All right, and this one I just had to Google to figure out what it was because Chris Christie's pretty damn smart with his acronyms. Do you use CEDAR's accounts for total FDIC protection, which I now know means Certificate of Deposit Account Registry Service?
We have. Promontory is probably preferable with the larger institutions.
What does that mean? So you guys use these terms. I don't know what the hell that means.
They're just bank terms, Mark. But yeah, fundamentally, the banking institution, whether it's BB&T or Citi or Deutsche Bank, Western Alliance. I mean, we've worked with dozens of banks, and they all have access to what is considered to be promontory. And that is a Federal Reserve system where they borrow FDIC coverage from other banks. And so there's like an overnight lending deal.
So that's a way to get over that 250 threshold?
Yeah, absolutely. I mean, so if you really want FDIC coverage, we just did a $500 million deal, and it was fully insured, fully 100% FDIC covered. Now, they were earning like 2 basis points on that deposit.
Right.
So if you insist on FDIC coverage, you're going to get paid nothing for the deposit. And if that's our fee and we're doing a lot of work, Matt, to talk about it. But balance sheet risk and dealing with, if I've got this amount of money on deposit, but it's no different than your IOLTA accounts. If you have a few $1 million, you may not even have FDIC coverage in your IOLTA unless there's special rules around that, because it's per claimant. But there's no question there's a benefit if you really do desire FDIC coverage. It's available essentially to $500 million.
Got it. All right, that's what I got for questions at this point. And I have a couple of planted questions for myself later, but we'll see.
Okay, great. So you had mentioned, getting an annuity for your firm, Mark. That's still available, but as everybody knows, interest rates are at 0, and annuities are yielding, maybe 1.5%. And they're irrevocable. So it's like back in the 80s, if somebody took out a 18% mortgage and they wouldn't have the ability to refinance it when interest rates went down. That's what an annuity is today. It's just the inability to refinance. There's no upside to them. So since 2003, which I mentioned, we can create tax deferrals, meaning you can put in an unlimited amount of money from a qualified settlement fund into a fee deferral. We use the term fee deferral, a fee deferral account. They go by different names, structured attorney's fees, etc. So if you're doing some Googling around the concept, there's half a dozen or so pretty reputable firms that do investment-backed, investment-based fee deferrals. And so there's an assignment company involved, as with all obligations. It essentially operates a lot like a structure. But fundamentally, our firm, we give you the ability to have your own investment advisor. We bring you the tax framework and the legal framework. Not all programs do that, but as you're evaluating, well, if I want to pay my taxes later, what do I got to do? What do I got to give up? You're going to give up some control, and you're going to be uncomfortable about the security until you really have done it or gone through the vetting and the due diligence. But all professional programs, candidly, if they're structured properly, and there's high sophistication in the legal and the liquidity, et cetera, it should be no different than a 401k plan with a fiduciary trustee. So we act as a fiduciary in managing the fee deferrals. If you come to us for the fee deferral plan, then we custody everything at Charles Schwab, the largest independent professional custodian on the globe. So you have real clear line of sight to your assets. So if you've done a fee deferral, where do they sit? They come out of the qualified sum fund and buy through our assignment company, and then they end up at a custodian like Charles Schwab for investment purposes. At that point in time, the fee deferral is no different than any other after-tax and wealth management account you might have and we've worked with all of the big private banks, J.P. Morgan, Merrill Lynch, Morgan Stanley, Goldman Sachs, etc. Wherever you are managing your money, you're more than likely familiar with custody, and where you get your custodian statements, we're no different. We don't hold the money. We only just provide the investment advice on it. So you can create a deferral. How that may look is, so if you settle the case for $3 million, and $1 million deferral, maybe you say, I'm going to practice 5 more years, and I'm going to start taking 10% of that account in 5 years. And so that's a 5-year deferral with a 10-year payment schedule. Our program uniquely gives people the ability to do a one-time full liquidation without demonstrating any hardship or for fee or penalty. So unlike a 401k, which has the 59.5 restrictions and also has a 10% federal income tax penalty for early withdrawal, fee deferrals, if they're structured properly, there should be no fee or penalty if you have to get access to your money. And so what that gives you the ability is to earn a lot. If you're having a big year, earn a lot of fee deferral money and have it invested and pay your taxes later. A lot of attorneys will ask us, what if taxes go up? Well, then you're going to be paying at a higher rate later on. But you have to keep in mind the mathematical equation of compounding interest. And if you are saving for your lifetime or for retirement or for a long period of time, the money goes in pre-tax before you're ever taxed on it, one, but then it also grows on a tax-deferred basis. So you're only taxed when it comes out of the fee deferral and you're paying yourself, and you have the ability to pay yourself individually as a lawyer or have it paid to your firm. So
John, let me interrupt for a second, because you jump from QSF to a fee deferral. Are those different entities and concepts, or is one flow into the other?
Yeah, no, they're mutually exclusive. You could just do qualified sum fund. It limits the amount of time that the fees aren't recognized by your firm to that 1 year, and so it's really a short-term play. But there's a lot of lawyers that just they'll use a qualified sum fund to even out that 1 year peak and valley. But for lawyers who they find themselves continuously, earning significant amounts of income,
that happens.
Yeah, yes. The fee deferral ends up being the follow-on, meaning that the qualified sum fund preserves the right of the lawyer to create that deferral, but they obviously don't have to. They could just shut the QSF down and take the fee. Whereas they may get to December that year and say, you know what, not only am I not going to need it next year, I'm not going to need it the year after. Things are looking good, and And so maybe if the conversation is really around when is the best time to recognize the federal income tax liability associated with that fee. So that's really, the fee deferral is absolutely separate. It's a second transaction, has nothing to do with the qualified settlement fund. They're mutually exclusive. So great question. But they do go hand in hand in that if you didn't do a qualified settlement fund, you would be negotiating with the railroad to get a fee deferral. And you all know that that's very difficult. And they're more than likely going to try to break off an annuity as they have people, and they have had people for 30 years. So doing a fee deferral directly with the defendant is just undesirable. And it doesn't give you the time and space to plan. You don't get to work with your own advisor. You inherit somebody from the defendants or the railroad, and you're going to end up with an annuity. I mean, like 99 times out of 100. So the qualified settlement fund, if you are interested in fee deferral, the pathway to doing it properly and professionally, in my opinion, is buying through a qualified settlement fund.
Now, if I do that, if I go with an attorney fee deferral, can I? You said it's held by Schwab. Am I limited in the things I can invest in?
Yeah, no, you're not. We have a bespoke, custom portfolio design process.
Did you just say bespoke?
I did. I'm sorry.
You're so fancy. All right, sorry.
I learned that last year. So, big word for me. Every one of our attorney clients that are in deferral can completely customize. So it's the complete investable universe: stocks, bonds, ETFs, mutual fund, whatever investment vehicle you actually want in your portfolio, we can design it. Or if you're working with your own financial advisor, they can script it, and we'll make sure that that's how it's traded and managed. And that all sits on Charles Schwab is for custody. So and you're not getting Charles Schwab investment product either. They're only the custodian, and so it's important. It's really the complete investable universe. I just had a attorney client text me this morning and said, "Hey, sell my Netflix and buy me some coin." Okay, no problem. So, it really is, you're allowed to run your money how you want. It's no different than, the wealth manager or financial advisor you're working with. And they can be included too. Obviously, they're not going to work for free. So you have to consider what the fee framework is going to look like. So unlimited options with regard to the investment choice.
So are there bespoke suits of leisure clothing as complimentary benefits for signing up for one of these? And actually, that is not my question. I'm just...
There are no leisure suit Larrys. Sorry.
Okay. All right. Fair enough. All right. As you were, go back to what you were doing. Those are all the questions I've had so far.
Okay. So far, so good. Thank you. So things to consider. The last piece is just, fundamentally, you directing where you get your custodial statements. You can be paperless, you can be email, you can have the app on your phone, whatever. You have 24/7 access to your real-time account. So that's why I say, that your reliance is on the custodian, not even our firm. Covered basically what attorney fee deferral is. If you want the citation, this is the 96 case in the 11th Circuit that really created the tax precedence. So a lot of CPAs will call and say, my client attorney is considering a fee deferral, and I'm trying to look this up where it says you can do this. Well, it's not expressly in the Internal Revenue Code because the IRS sued Kenneth Childs in 96 and lost. And so, but there's not been a lower tax court ruling anywhere in the country in now, 27 years. It just means that the IRS is not picking a fight with this fee deferral concept. And it was codified in 2004 after the Jobs Act, where they created 409A, which is the deferred compensation set of rules for executives. And they specifically carved out all service providers to include attorneys. And so they had an opportunity to kill the business or shut down the ability for contingency fee trial lawyers to defer an unlimited amount of income, and they didn't because they just was going to be challenged. So I think they just prefer to stay out there. And fundamentally, you're going to be 1099 in the year of receipt of any income from a fee deferral. So the IRS, they're not getting shortchanged on any amount of taxes. They just have to wait. And so while they're waiting to get paid as your silent partner, in your business activities as a trial lawyer, you can get it invested and do well with it, hopefully. A little on tax precedents. I talked about some of the benefits, but there's no rhyme or reason. I mean, people come to us all the time with, hey, I'd like to set up an education fund for my kids. They're 5 and 10. And they peel off a fee deferral and they fully pay for their kids' college in the years that they're 21 to 25 or something like that. So it's completely customizable on when you receive it. I've had couples come to us where they're both lawyers and they say, we're going to retire in 10 years. Let's just take these 6 cases and earmark them for the qualified summon fund. And we're going to defer the fee on all 6 of those cases. We just are running a successful practice. We don't need that cash flow. So in terms of design and flexibility, it's the open universe in terms of whatever your ideas are. It does have to be invested in a actual security, a listed security. So it can't be a boat or a home. Unfortunately, I've had those questions before. But so if you want to invest the money and have it grow and have the growth pay your tax obligation on that, that's a big one. I went through a couple of case examples, and I covered the investment portfolio. But the biggest decision for most attorneys is how to design the distribution schedule. I have these conversations literally every day, half hour, hour and a half, and it's like to put in context. You just think about the fee deferral as kind of that third leg of the stool. You got your after-tax monies invested somewhere. You might have a SEP IRA or a profit sharing plan or 401k, which is tax deferred. This really can become that third, quadrant, if you will, for building wealth for your family. But you have to decide an irrevocable distribution schedule. Even though you have the right of liquidation, if you set a 10-year plan, we as the administrator must comply with the distribution. You can't come to us in 2 years and say, I know I designed this a 10-year, but I really wanted a 15, or now I need it to be 8 years or whatever. You can't change the contract in the year of deferral. So there are limitations, to the design, and it just takes some time working with an expert settlement planner to understand how the fee is going to fit in. And we always recommend, candidly, that whatever lawyer may choose to do a deferral, that they also have plenty of liquid cash on their balance sheet, that they hope not to need that money, at some point. The liquidity feature is there if they do, but you don't want to have to accelerate it. There's no fee or cost for accelerating it, but you want to plan for a successful financial outcome fundamentally.
So let me interrupt for a second then.
Yeah.
How is that different? Like an annuity, it's locked in. And unless you sell the annuity and take a bath, get hit for a few points on selling the thing, how is that different from doing an attorney fee deferral if once you're locked in, you're locked in?
So we access the same state law that the annuity industry accesses for liquidation. But because we're the administrator of the fee deferral, we just choose not to have it discounted. You're not having to sell it to a third party at discount and take a haircut, Mark. If you have $1 million sitting in your fee deferral, we in advance in our contract say if you exercise your liquidation clause, then we are accessing the state law that says that periodic payments can be liquidated. You don't have to prove hardship, and we provide you the account value, period. So the framework of the law is there. Look, if people were willing to pay fair value, they wouldn't have to take a haircut on the annuities either. It's just that market is not very robust. So that's why there's a haircut. But because these are your assets and they're invested, and we can liquidate the securities and provide you with a wire and the account value within a couple of days, we've designed this fee deferral to be sophisticated so that lawyers like yourself are like, oh, I don't want the gotcha. There's no gotcha in this plan. It's fun. It's not right for everyone, but we've walked the dog on what is best practices from a security perspective, best practices from an investment perspective. If I were a plaintiff lawyer, what would I want? It's something very close to this. So I don't think you guys need the examples. Candidly, I can probably bring it pretty close to a close. There were a few things that Mark mentioned that we also specialize in. We set up special needs trusts in all 50 states. If you have a client on Medicaid, call us. We can help, no question. There's a range, even if it's a small case, 50, 100,000. Medicare set-asides, if you have any questions about Medicare or Medicare beneficiary, whether it's a railroad case or otherwise, we take the position, an aggressive, even though Mark introduced me as a non-aggressive personality.
Personality, I said. I didn't say your
personality. That we take an aggressive legal stance on Medicare, that the U.S. Supreme Court in the Chevron case explicitly set forth a three-pronged test that no agency of the government can exact a penalty on a constituent of that agency, and we're talking about Social Security, if they don't promulgate regulation, and there are no regulations with regard to liability settlements, which all railroad settlements would be, even though it's FELA. So we're fair. We do a lot of memorandums for lawyers that say that the government's interest is zero. Now, if it's a workers' compensation case under state law, then you might have to do a Medicare set aside because it's comp, and so it just is what it is. But there are a lot of companies out there that make a lot of money, setting up set asides, and I've seen literally millions of dollars get put into Medicare set-asides that would otherwise have just been the client's money. And so we have an excellent belt and suspenders approach to protecting your client's interest, providing your law firm with the CYA on Medicare, and the allocation should be zero, like 99.9% of the time. And we charge like $500 for those reports. So if you have a vendor or someone that you've worked with that's been putting your clients a lot of their money in set-asides, you may want to look at that again. I don't have time to cover that, but happy to take a call directly if any of you are dealing with significant set-aside issues. Conditional payment's different, and you got to pay back the government if they've given your client. There's a conditional payment, obviously. So that's for the most part the sum of our presentation.
Well, hang on. I still want to ask about this Bears Foundation thing.
All right, I did. I covered that in the beginning.
I know, but I want to circle back to it because and there are limits to it, meaning the amount available. But I think that it's a laudable reason for the limits too. So, because for example, I know that I tried to put one through, and you folks said no, and once it was explained to me, I understood why. So. I'd rather folks hear it up front because at first I was like, well, gee whiz, I'm ARLA, and maybe it was just me. but when you guys explained it, I got it completely.
So we have a board mandated, we cannot advance more than $25,000. And just from a practical perspective, we tend to not advance more than $10,000 or $15,000 for any one plaintiff.
And why is that?
And it just to spread the risk fundamentally. One, knock on wood, we have a 100% repayment rate. So every lawyer has paid us back that brought us a client to advance money to. They didn't guarantee or promise anything. We still write these agreements non-recourse like the rest of the litigation finance industry. But the beauty of that is if you live in a state where the law says it needs to be recourse, we're also happy to do that because our rates are not usury. And, we're so far well below whatever the cap is at the state, and we've researched all 50 states. So we can write in Colorado. Supreme Court said in Colorado that it's a loan. And so all the funders left Colorado. Same for Maryland. So as states approach consumer protection in litigation finance, a lot of these funders' profit margins, they're just going to pull up stakes and go to Idaho or Wyoming where they can continue to rip off plaintiffs. There's very little consumer protection, maybe 3 or 4 states, but because our rates are so low, we can write anywhere and we can write recourse. We're never going to go after a plaintiff to repay us, even if their settlement is zero, if you get a no cause. So even though we may write the contract as recourse, we're just not in the business as a nonprofit, as a philanthropy, shaking people down and filing UCCs and doing all that stuff?
I'm not sure this is really going to be one for you to answer, but do you know if there have been any decisions or discussions, and this is a legal question, on the discoverability and admissibility? Have you ever received a subpoena, for example, on for paperwork that anybody has submitted to you in connection with the litigation funding during the course of a case?
So I've never been subpoenaed. Discoverability of litigation finance contracts, I think, is still working its way through the courts. I attended the Judicial Institute conference in Berkeley 2 years ago, and you had Judge Polster. There were a dozen federal judges there, and they spent about 8 hours taking panel from defense lawyers in the industry and plaintiff lawyers around, what their best practices are. And so what I think a lot of judges are that they can be educated around, if there is a demand for admissibility or discoverability, that plaintiff lawyers should go to the judge and say, look, you can do an in-camera review of our contract. There's no conflict. No one else is running this litigation except for a plaintiff lawyer. I know that there was just a significant case, which I'm happy to share with the panel and attendees, in an opiate case where the judge did make a decision to do in-camera review of any third-party litigation financial contracts. And that's fundamentally, those are your, RIMs, DIA. I mean, your behemoths on the defense side, they want to put some sunshine around these third-party litigation contracts, because that's where a lot of the money that the trial lawyer community is getting funding for marketing to get more cases, et cetera. It's not necessarily the little subset that is the consumer, the little guy that some plaintiff borrows $6,000. They're not necessarily going after that per se, but it's all litigation finance. And if they want it to be discoverable, we take the position and we advocate for there to be consumer protection. It's one of the things that we're doing with our foundation, is to educate legislators about why litigation finance for the plaintiff is so vital. It just shouldn't be a ripoff. It shouldn't be so expensive. And so Chamber of Commerce would like nothing more than to see litigation finance go away altogether, defund the trial lawyers and their clients. Because if a client can't survive financially, they're going to buckle. They're going to settle for less. And that's not good for the lawyer or the client. And so, litigation finance done properly does have a home in civil justice that I think is appropriate. And so doing it through a philanthropy, I think, is the answer. We want to be replicated. I have no interest in life in managing some $50 million loan fund. But what we're trying to do is set an example to say it can be done. It can be done in your state. I'm happy to talk to any nonprofit in your state to say, you want to get into the litigation finance business and you want to and we're a benefit to the trial lawyer community, I can show you how to do it. We got 6 years of track record now, and we're doing some good with it. But it's a big, big industry, Mark.
And then the last one, you may as well just give a brief promo on where the scholarship idea came from.
Yeah, sure. I mean, so I've been a advocate for ARLA, now AJ, for the last 23 years, and only about 18% of the membership of most trial lawyer organizations are women. I personally think that the bar at large, the plaintiff's bar at large, would be better if there were more diversity. Partnerships are stronger with diversity. Look, the Fortune 500 CEOs have figured it out. Their boardrooms are packed 50% with, people of all, creeds and color and gender. And so we chose as an organization to create a scholarship for a rising woman 3L to encourage them to get into the plaintiff's practice, because that's good for the plaintiff's bar. And so that's fundamentally where the idea came from. We're not discriminating against guys, but I
don't know that you really can't, because look, this organization is a perfect example of what you're talking about. I mean, the paucity of female membership is obvious, and we're doing what we can to recognize. So that's why I wanted to talk about it, because I think what you're doing is great. So
yeah, thank you. I mean, everyone could do a little bit more, right? I mean, so
Yeah.
we've been a successful firm and we've done a lot of good work for people. And so we have the ability to give back. And just one of the ways that we're choosing to do that, the foundation is the biggest one, but the scholarship is a fun thing that we're doing. And it'll help, one woman in the country once a year. It's a $10,000 scholarship. So it's not, some nuisance money. But they're going to have to compete for it too. And so if anybody that's a member of ARLA wants information about the scholarship because they want to share it back to their law school, their alma mater, wherever you guys went to law school, put it in the notes or, send me an email. We're happy to contact the dean or a law professor and make sure that law school is aware of it. So it's national and it's available to any applicant.
Great idea. All right, folks. So this would be the point where if you had additional questions that we haven't covered, although candidly I find that tough, but this would be the place to do something about it.
I will come back just as a caveat that we do a lot of estate planning with the fee deferrals. And that requires like a whole another hour conversation or more. But if any of you are thinking about how to get money to your grandchildren or do something philanthropic, either through your will or estate or something like that, you can plan it in a fee deferral. And that's just an awesome concept. We have guys in their 60s and 70s to say, look, I've made all the money in my life. Now I want to plan smart from a tax perspective and get more money to my next generation. We have highly sophisticated estate planners, lawyers that that we can put a team together to talk about that too. So really, it's whatever your challenge is, whatever your problem is. We put a good professional team together for that, and it's worth mentioning.